Well, hello again, Attorney Lydia Menendez here. I want to tie up a couple of points I made in my prior videos. Remember I said that wills must be presented to the court for administration? That is known as the probate process. We have another video on probate that talks more about it. But for today, what you need to know is that when somebody passes away, the court has to appoint the personal representative for the estate that is created when that person passes away. The personal representative is the person that will be responsible for managing the affairs of the estate. Until that person is appointed by the court, no one really has authority over the assets of the estate. So what happens to the assets in the meantime? Well, it depends. In other videos, I've mentioned assets of sentimental value, life insurance, retirement accounts, and even homestead property. But have you considered what would happen to a business interest? How does that business continue to operate? Remember, a will activates at death, so there is really no plan in the event of incapacity, and in the event of death, the will would need to go to probate to be administered by the court, which is a very disruptive process, including the fact that it is very lengthy. What if you have a business partner? What happens to your business? What happens to your interest in the business? What will happen to your family? Let's use a very simple example. What if you own property which you rent from which you generate income? Who will continue to operate that business or that property if you become incapacitated or if you pass away? The answer is that until the court issues an order appointing a guardian or a personal representative, no one has the authority to manage the assets of the estate. In other words, the assets would be in limbo land. In sum, whether it is an untitled asset like the collection of books, an asset with beneficiary designations like life insurance and retirement accounts, or titled assets like real estate, the use of a will and nothing more will most likely not accomplish what you want or intended. And equally disappointing is the fact that if you had a will, you took steps to plan and probably thought that you were all set. Instead, you and your family are faced with uncertainty, disruption, and the additional unexpected expenses of having to go through the judicial probate process. There is definitely a better way. Visit our website to register for a free webinar where you can learn all about the proper way to plan your estate and avoid these pitfalls. If you like this video, please like and share. If you want more videos about estate planning, subscribe and ring the bell to be notified when the next video is released. Thank you for watching and see you soon.